Yes, Mr. Drowell.
Lord, can I pick up where we left off and deal with I'm anxious that we deal head on with the practicalities of why it is that local authorities want this sort of injunction and who is likely to be caught by it, and why, and in fact why it was that Mr. Justice Nickling held that they plainly weren't entitled to an injunction contra mundum or on a very wide basis. Probably won't do this adequately this afternoon, but that question about the practicalities is dealt with Mr. Justice Nickling's judgment, and I will take your lordships to the relevant passage now. And also in Bromley, which I was going to go to, Bromley is a very important decision for considering the practical implications for the gypsy and traveller community of the sort of injunctions that are being sought, and granted on the basis that it was a jurisdiction exercised against identified or identifiable individuals and subject to a whole raft of safeguards. When we move on to the injunction being granted against, well, I keep on saying people who don't exist, but to newcomers. Let's say newcomers. Then the practicalities are different, and I just want to show your lordships what Mr. Justice Nickling said about that. And if I could take your lordship to his judgment, first of all at page 406.
Do you mean 406?
No, I've got the number. Paragraphs 43 to 46 of the judgment in any event.
43 to 46. 506.
Work of my printer, I haven't always got the EF numbers at the foot of the page, but anyway, what I want is paragraphs 43 to 46.
506.
Actually, picking it up on paragraph 42 on the earlier page. The order for alternative service in London in Barking and Dagenham's claim was technically defective, did not state the date on which the claim form was deemed to be served.
I'm sorry, where are you reading from?
Page
Paragraph
505.
42, which will actually be 505.
Yep.
So the order for alternative service in Barking and Dagenham claim was technically defective. It did not state the date on which the claim form was deemed to be served. It was impossible, therefore, to identify the date for compliance. No doubt this is an oversight, which is consistent with the theme that's emerged on investigation of the cohort claims, a lack of consideration of the fundamental question whether the proposed alternative service of the claim form on persons unknown could be reasonably expected to bring the proceedings to the attention of those who were sought to make defendants a civil claim. My impression is that as far as service of the claim form on persons unknown was considered at all in the cohort claims, it was done imperfectly. Mr. Rulewski's witness Mr. Rulewski's witness statement, for example, did not address why an order for alternative service of claim form was justified or appropriate, or the basis on which the court could be satisfied that the method of alternative service is likely to be an effective way of bringing the proceedings to the attention of the defendants. In fairness, he prepared a witness statement in the application for alternative service before the Supreme Court decisions in Cameron did not have the benefit of the decision's focus upon the need to demonstrate that the proposed method of alternative service could reasonably be expected to bring proceedings to the attention of persons unknown. Nonetheless, had Mr. Rulewski asked himself, for example, when the claim form was likely to come to the attention of the person unknown defendants, he might perhaps have identified the artificiality and reality of the method he was proposing as being likely to bring the proceedings to the attention of someone other than those presently in occupation of any of the injunction sites. I recognise that the method of service he proposed reflected the well-established regime for possession claims against unknown trespassers, and there can be no real doubt that in a claim against alleged trespassers in present occupation whose names are not known, displaying prominently the claim form or copies of it on or around the various sites in respect of which an injunction was to be sought can usually be expected to bring the proceedings to the attention of the defendants. However, the whole point of traveller injunctions was to bind persons who turned up at the land only after the injunction had been granted. In respect of that category of defendant, posting the copies of the claim form at the various sites was not likely to be an effective means of bringing the proceedings to their attention. To take an obvious example, displaying copies of the claim form at the Dagenham Road car park or at any of the other sites covered by the injunction was not likely to bring the proceedings to the attention of a family of travellers in Rochdale. The first such a family was likely to discover about the proceedings that had led to the injunction being granted against them was when they subsequently pitched their caravan for an overnight stay in the Dagenham car park. It may be, it's the next paragraph is relevant too. It may well be that the importance of this aspect of the decision in Cameron on claims against persons unknown has not been fully appreciated in the cohort claims. However, since the Supreme Court decision in Cameron, the point has been authoritatively determined. In a claim against persons unknown, the method of alternative service of the claim form permits the claim form that the court permits must be one that can reasonably expected to bring proceedings to the notice of all of those who fall within the definition of persons unknown. Without that safeguard, there is an obvious risk that the method of alternative service will not be effective in bringing the proceedings to a perhaps significant number of those in a broadly defined class of persons unknown. By dint of the alternative service notice, they would be deemed to have been served, when in fact they have not. A point that becomes important when the court comes to consider granting final relief against persons unknown. And then it says that offends the Cameron principle. Now, the main reason for reading this is, the reasoning is important, but will be sidestepped by this court approving an order in the form you were discussing immediately before lunch, i.e. time limited with a very time limited, and either with a sunset clause or with a liberty to apply, or both. But the point is that there's a temptation to view the body of gypsy and travellers as a cohort. I mean, that's to lift the word, used in a slightly different context here, when they're not. We're dealing with a nomadic population whose lifestyle indicates that they will move around the country. Therefore, you have to be able to deal with the sort of example of the family, say a travelling family that moves with a circus or whatever, resident in the north of England one day, and coming somewhere else to the Midlands on another day. You're not dealing with an identifiable cohort moving from wood to wood as you were in Maya. You are dealing with a community composed of different individuals, all of whom are potentially affected and indeed bound by, on the reasoning of the Court of Appeal, an order which has nothing to do with their personal circumstances. It may have to do with some of their personal circumstances, but not by any means the personal circumstances of all those who are identified in the order. And that's, in my submission, quite important practical point that underlies the approach that was taken by Lord Justice Coulson in Bromley when we see the discussion of proportionality and so on. I'll come to that.
But does it depend on precisely how the target class, if I can call them that, are identified in the documents to be served, either the claim form or the injunction?
Well,
I mean, they can be identified broadly, or they can be identified probably with slightly greater specificity, presumably.
Well, your Lordship says presumably.
Well,
that's quite an important.
I'm not familiar with all the different orders that have been made.
That's quite an important word, because if you're dealing with a group of people who are moving from a neighbouring borough to this borough, and you can say there's an immediate threat, you were able to identify them by one form or another. The problem we are grappling with is the jurisdiction to grant an injunction against newcomers, that is, persons who can't be identified in any way, in which case you have to cope with the individual who is in Rochdale, to use the example that Mr. Justice Mickling is dealing with, who moves for various reasons because they are an itinerant community to one of the boroughs that has a very large injunction covering much of its area. You have to be able to deal with that possibility. And the Court of Appeal, we'll see what the Court of Appeal says about Bromley, and we say their reasoning for rejecting Lord Justice Coulson's warning in Bromley about the need for proportionality and to deal with the Article 8 risks, rights of the travelling community is mistaken. We say the present Court of Appeal got it wrong when it doubted the approach of Lord Justice Coulson. You have to deal with the fact that you've got a community that travels, who travel in pursuance of a right which the European Court has recognised as backed up by their Article 8 rights, and is not a coherent body of people who are travelling from one site to another, not the risk at which these injunctions are targeted. So for those reasons, we say that any injunction has to accommodate the example in paragraph 45. And we will also say that Mr. Justice Mickling was correct when he repeated that. And we invite your lordships to read with, obviously, care, sorry, that was presumptuous, the judgment of Justice Coulson in Barking for the background to all of this, which requires a proportionality analysis carried out at the time the injunction is first granted. Now, if we then go on later in the judgment, there's a series of paragraphs which start at I'll start at page 221. Deals with the example that I've been dealing with. Say paragraph 221, page 558. Sorry. And I'm going to this passage for two reasons. One is to look at the reasoning of the judge on whether contra mundum injunctions were legitimate, and his approach to Venables, which is one of my remaining tasks, to explain the jurisdiction, the basis of the jurisdiction on which Venables was made. But secondly, also to look at his treatment of the practicalities. If I can pick up at the foot of page 557, paragraph 220. We have this passage. Mr. Willers, on behalf of the interveners, submits that the court has jurisdiction to grant country mundum injunction orders Venables. Whatever its origins, the modern basis of statutory jurisdiction is Section 6 of the Human Rights Act 1998, RxG, the Ministry of Justice. And I'll go to Venables in a moment. The basis of the jurisdiction is indeed the duty placed by Section 6 of the Human Rights Act on the court as a public authority to uphold convention rights. That's how it was explained in Venables, and I'll go to that in a moment. And then Mr. Willers went on to submit the claimants in the cohort claims cannot invoke this jurisdiction because they cannot meet the criteria. The contra mundum traveller injunction is by definition, almost by definition, disproportionate. It does not discriminate between a large encampment causing massive disruption, damage and nuisance and a single caravan peacefully parked overnight in a local authority car park, where, as recognised in London Borough of Bromley, the Article 8 rights of the Gypsy and Traveller communities are affected by the grant of such traveller injunctions. The court has to consider the necessity for and proportionality of the interference that a traveller injunction represents. On the point of whether the local authorities can demonstrate it is necessary for the court to grant contra mundum injunctions, Mr. Willers relied upon the guidance published in March 2015, dealing with illegal unauthorised campments.
Now, do we have that in our...
We do. I've been thinking that I might need a more structured note on the material that Mr. Sure we do. Oh, well, perhaps we don't. I thought it was in the additional material. We will ensure that the court has it in any event. It is referred to in...
Is this guidance issued by central government?
Yes. And if your lordships go to Bromley, you will find Lord Justice Coulson dealing with the whole of this background in some detail, which is why the decision's important. Just for your lordship, covered note, if your lordships go to page 2190, there's a heading in Lord Justice Coulson's judgment in Bromley called Guidance, and that deals with it all. I will certainly give some thought overnight about whether some more structured approach is necessary, although the job's been done in Bromley. The point that's being made here is the same that was made in Canada Goose. On the point of whether local authorities can demonstrate that it is necessary for the court to grant contramundum injunctions, Mr. Willers relied upon guidance, then there's the heading, and identified what were described as extensive powers available to local authorities, including stop notices and temporary stop notices under the Town and Country Planning Act, licensing controls of caravan sites under the Caravan Sites and Control of Development Act, possession orders, including interim possession orders, where available under Part 55, local bylaws made under Section 235 of the Local Government Act, including the ability to attach powers of seizure and retention of property in connection with any breach of a bylaw under Section 150, subsection 2 of the Police Reform and Social Responsibility Act 2011, directions pursuant to Section 77 of the Criminal Justice and Public Order Act 1994, various provisions of the Highways Act to deal with obstructions of the highway causing a nuisance, planning contravention notices under Section 171C, and enforcement notices under Section 172 of the Town and Country Planning Act. The guide also identified powers that the police could exercise to tackle unauthorised enforcements. So there's a whole background of a raft of enforcement possibilities available to the court.
What's an interim possession order?
Sorry,
What is an interim possession order?
what is an interim possession? That's a very good question. I've been told even by those in my hurry. That's a very good question.
I'd be fascinated to know.
I think its importance is timing, is it? Yes, I think so. I've been told it's an order made against someone who entered the property as a trespasser, and I anticipate that its importance is timing, but I will get a detailed answer to your lordship's question. And then with a submission in 222 also goes to the discussion we were having earlier, insofar as reliance was placed on the permission to apply provisions that were included in the Wolverhampton injunction, and generally Mr. Willers submitted that this did not make up for the disproportionate impact of the injunction order. He admitted it was fanciful to suggest that a family of travellers who arrived at a location to find that an injunction is in place prohibiting them from stopping there would lodge an application to the High Court asking for the injunction to be varied. And I repeat that submission. Mr. Justice Nickling went on, 224, my judgment in civil proceedings, Section 37 of the Senior Courts Act confers jurisdiction on the court to make contramundum injunctions. However, the circumstances in which the court will exercise its jurisdiction are very limited, and are practically restricted to cases where the contramundum order is the only way to protect an engaged convention right, and where a refusal to do so, a refusal of an injunction will put the court in breach of Section 6. This self-denying limit on the grant of contramundum in orders recognises and gives effect to the principle of natural justice explained by the Court of Appeal in Canada Goose at 89.
I see in that case it seems to have been common ground that the basis of the jurisdiction to make a Venables order was Section 6 of the Human Rights Act.
Yes.
I don't think we would necessarily take that for granted. I mean, if the Human Rights Act were abolished, were repealed, would it follow that the court no longer had jurisdiction to make a Venables order? Discuss.
Yes. Also, it's
quite a large question.
It's interesting what the judge says. I mean, the first sentence is that Section 37 gives the jurisdiction, and then he speaks about there being a self-denying limit.
Yeah.
So it looks as if the court, having been given the jurisdiction, then in the interests of justice, the interests of natural justice, has limited the circumstances in which it has chosen to exercise that jurisdiction.
Yeah, so that goes back to what I was attempting rather badly to say before lunchtime, that the cases are, when they come to actually, well, the difference between jurisdiction and practice in the practice of the courts, draw a distinction between full jurisdiction, that is, literally, does the court have power to do the thing that's asked for? And secondly, is there some principled limit to the exercise of that jurisdiction?
Well, that's what
the
I'm
word
suggesting.
jurisdiction is used both ways.
Yes.
Now, rather sometimes confusingly, no doubt by me, but there is no doubt that what the judge is saying in that sentence, that there's jurisdiction under 37, is the first sense, full jurisdiction, consistently with the whole line of authorities about how injunctions work between against people who are within the personal jurisdiction of the court, then that is the practical limit on the grant of the injunctions, and it's a big thing for this court to say that limit should be ignored or overridden or found distinguished in circumstances where there's a whole range of other solutions to the problem which Parliament has explored and which local authorities could explore.
Yes.
And the court 225 has further comments about the basis of the contramundum and jurisdiction. (226) refers to the submissions made by counsel for the local authorities being powerfully argued. And then comes this submission by Mr. Willers. Mr. Willers QC countered that there are clear limits to how creative the court can be in pursuit of a remedy for a wrong. One of those limits is the position where a court's rights are infringed by an unidentifiable wrongdoer. That is precisely what happened in Cameron. There was no dispute that Miss Cameron had been injured by the negligence of another, but because she could not identify the other, the court could not assist her. It made no difference that this deprived her of a remedy. He argued that this completely demonstrates the limit of the maximum quoted by Baroness Hale, in fact in Mayor. He argues that he was responding to this siren call that led the majority in the Court of Appeal in Cameron into error, finding jurisdiction where there was none. In his submissions also encapsulated the danger of not respecting the proper limits to civil litigation. The civil courts determine disputes between parties. They uphold rights, but they do so within the context of inter-parties disputes. The court's role as arbiter rather than inquisitor is why the system is adversarial. The proceedings brought by these claimants are a qualitatively different to the inter-parties arguments the court is designed to decide. The proceedings are not, and are not intended by the claimants to be, a determination of a dispute. Rather, they are intended to confer on the claimants a new power, enabling them to police public disorder using the court's enforcement mechanisms. This is not an appropriate use of civil litigation. The purpose of the court's enforcement powers is to give effect to its own judgments. They are not designed as a general control on wide-ranging antisocial behaviour over large geographical areas. Moreover, it puts the court, whose role is to determine disputes, in an invidious position because it makes a process designed to be adversarial inherently one-sided, contrary to Cameron. And then your lordships will see that Mr. Justice Nickling says he accepts those positions, subject to a point about interim injunctions in paragraph 229. And in paragraph 230, it cites paragraph 92 of Canada Goose, and then it says if these established principles and limits they impose on civil litigation are not observed, the court risks moving from its proper role in adjudicating upon disputes between parties into effectively legislating to prohibit behaviour, generally by use of a combination of injunctions and the court's powers of enforcement. There may be good arguments as to why such behaviour ought to be prohibited, but it's not the job of the court through civil injunctions granted contramandum to venture into that territory. Stepping back, the injunction that Wolverhampton was granted with a power of arrest attached effectively achieved the criminalisation of trespass on the 60 or sites covered by the injunction. In a democracy, an adversarial legislation is the exclusive province of elected representatives. A court operating in an adversarial system of civil litigation simply does not have procedures that are well suited or designed to prohibit by injunction conduct generally. Parliament has required that local authorities seeking public safety, get off PSPN. Yes, it's public spaces protection orders must carry out consultation before making an extending or varying a public spaces protection order, leaving aside the constitutional objections based on the separation of powers. The court has no way of carrying out any sort of consultation as part of determining a civil claim for an injunction. The Court of Appeal noted in Canada Goose, and then the site. I cite paragraph 92.
Mr. Travellers, there's a deeply embedded assumption in those paragraphs that civil litigation is all about the resolution of disputes. It might be said against you that the largest single class of civil claims, at least in 2016, when I was looking at it, and I think still now, are claims to enforce usually contractual rights about which there isn't any dispute whatsoever, but where the claimant needs a court order in order to enforce his right. I only mention that because, speaking purely for myself, the concept that all civil litigation and all civil remedies are dispute resolution remedies, I don't find actually easy or statistically necessarily right.
No, but in an enforcement context, if I can just follow through the logic of what your lordship is putting to me, in an enforcement context, there may be no dispute about what the contractual provision says, but there may very well be a dispute about whether the grant of the remedy is appropriate. And in order to resolve that issue, you have to have the party against whom the remedy is being sought in front of the court, subject to the personal jurisdiction of the court, and the language I've been trying to use. Now that's the position here. As a matter of civil law, a gypsy who goes onto one of the numerous sites covered by the injunctions is trespassing. There's no doubt about that, but that has to be read against a background considered in Bromley, in which the gypsy is a member of a community whose rights to travel have been recognised by the European Court in a series of decisions under Article 8, either as a home or indeed private life, and in which the proportionality of the remedy has to be decided. Now, that is a dispute. That is a potential dispute about whether it's legitimate to grant the order. No doubt that there's a trespass, but a lot of doubt about whether the application of the approach in South Bucks and Porter would lead, in the Rochdale example, the individual in Rochdale who goes along with his fare to finds himself in Warsaw and needs to camp on a site, whether it's proportionate and consistent with his article that it writes to remove him immediately. Now, that is a dispute. So, with my submission, Mr. Justice Lickling is entirely correct in the analysis. It's just that one needs to recognise what is the potential nature of the dispute. I fully accept that in trespass cases, there's no doubt about what the position is as to whether the tort of trespass is being committed. But the courts have very firmly said that's not enough to justify the immediate grant of an injunction because of the other public policy considerations. And almost my job this afternoon is to ask the court to think very hard about the practical implications of an injunction granted against the world or against persons unknown, which have not considered at the outset the proportionality implications of the grant of the injunction or its enforcement.
Is the practice of the courts in granting these orders against identified persons, is that practice including a proportionality assessment presented to the judge before the interim order is sought? Do you know?
Well, it's certainly a requirement of Bromley that the proportionality of the injunction has been considered. We've seen from Mr. Justice Nickling's description of what the position was when this wave of injunctions was granted, when that exercise wasn't carried out. But that's precisely what led Lord Justice Coulson to lay down his approach, which includes an assessment of proportionality in Bromley. So we do say, if you, Gypsy, move on to a site and trespass and possibly breach planning control, probably both, then the case law requires that before you're moved on, if no damage is being done, it all depends on the circumstances, then the proportionality of the grant of the injunction and its enforcement are considered. And one of the vices of the approach of the present Court of Appeal is that it sidesteps that. You grant the injunction without knowing the identity of the individual whom you're injuncting, because he's a newcomer. You don't consider the proportionality in the context of his case. Yeah. But when he comes to, when he turns up and finds a sign on the site saying there's an injunction, it will almost certainly go away in the practical circumstances. But if he doesn't, is 1 foot is behind.
No, but if most of the interim injunctions are granted ex parte and the travelling community don't have the resources to come and carry out an adversarial hearing, then the mischief of an inadequate assessment of the traveller's Article 8 rights could apply equally to an identified defendant as to an unidentified one.
Well, that is obviously subject to the requirements of the guidance given in Bromley to the court to carry out a proportionality exercise, to make good to some extent the fact that routinely there won't be actually two adversaries in my adversarial system, because the gypsy will be unrepresented and unlikely to make the application.
You're going to take us to Bromley, presumably, are you?
Yes, I am going to take us to Bromley.
It's just
quite a long judgment. I'm not going to be able to read it all, but it is important.
I was just wondering if the difficulties facing the travelling community is much wider than simply the unidentified, the unidentified defendant.
There's no doubt about that. I mean, I'm not for a moment suggesting that this litigation produces an answer to the fairly acute problems that the travelling community faces because of the absence of official sites. I mean, put shortly, that's what is said in Bromley. So there is a big underlying problem, but for the purposes of this litigation, what it means is that if you carry out an analysis about whether there is a dispute, a potential dispute between the people who are newcomers and who are bound by the order, although not in front of the court, and the local authority? The answer is yes, there is a dispute about the proportionality of the remedy. The gypsy community may not be in a position to do much about that in the ordinary case, but that doesn't affect the fact that the court is being asked to grant what I call a final order, but in whatever form one describes it, an order which is postulated on the basis that the newcomer doesn't have a case which would justify not making the order in the first place.
Can I just be sure I understand why the travellers are trespassers? The land might conceivably, I suppose, be land to which the public were not admitted. But it seems more likely to be land to which the public are admitted, either as licensees or because it's held on some trust for the public as open space or recreation ground or something of the kind. And is it simply so they're not, in that event, they wouldn't be trespassing simply by setting foot on it?
No.
So is it the nature of the use they want to make of the land which goes beyond what the public are permitted to do and therefore constitutes a trespass?
Let me just see whether Mr. Willett, I don't want to be making concessions which I shouldn't be making. One may need to be careful about precisely what situation you're dealing with. There are cases where the cause of action, putting it loosely, is not a cause of action, but where the problem identified by the local authority in asking for the injunction is a breach of planning control. And there's a specific power in Section 187 large B of the Town and Country Planning Act for injunctions to be granted to restrain a breach of planning control. So that doesn't depend on the trespass jurisdiction. The argument of local authorities in other cases will be that the user goes beyond a conventional user of the land and is therefore a trespasser. We'll see the way in which the the Court of Appeal in our present case approached it. It did definitely approach the basis that was a trespass. I'm not primarily concerned to argue about that, but I do argue about whether that means there's no dispute about the availability of the remedy in the conventional gypsy, in the whole range of gypsy cases with which we're dealing. And just as a matter of information, Mr. Willers and those he acts for don't routinely accept that there is a trespass. It depends on detailed analysis of the situation. But in any event, my more fundamental point is that even if there is a trespass, and therefore no dispute about the rights and the rights of the parties at that stage, there is a dispute, or maybe a dispute, about the availability of the remedy. So if we go back to page 561, paragraph 233, page 561, para 233, can the local authorities demonstrate that traveller injunctions fall into the exceptional category where the court is compelled to act by way of a contramundum injunction? In my judgment, the answer is plainly no. There is no doubt that traveller injunctions engage Article 8 rights, the Article 8 rights of gypsies and travellers. See London Borough of Bromley. Insofar as the remaining local authorities in the cohort claims now raise an argument that the relief sought also engages the Article 8 rights of the denizens of its area, then the court will be required to perform the required parallel exercise when considering whether to grant an injunction, and if so, on what terms. The court's task in doing so was explained by Sir Mark Potter in the Local Authority VW, The exercise of the parallel analysis requires the court to examine the justification for interfering with each right, and the issue of proportionality has been considered in respect of each, not a mechanical exercise to be decided on the basis of rival generalities. An intense focus on the comparative importance of the specific rights being claimed in the individual case is not necessary. It's not necessary before the ultimate balancing test in terms of proportionality is carried out. Sorry, is necessary. Substituted a not in that sentence. And then picking up whether the next paragraph is really examining whether that exercise is possible. The submissions made by the remaining local authorities in support of traveller injunctions might be thought to be paradigmatic examples of rival generalities. Indeed, the whole structure of persons unknown litigation and a fortiori claims for injunctions contra mundum, because there is no focus on individuals, means that the court can only carry out any assessment based on rival generalities. Worse, it's an assessment that carries a significant risk of inbuilt prejudice. On the basis of evidence of the worst examples of historic wrongdoing by some unidentified persons, the court is asked to impose an injunction to restrain future conduct of unidentified and unlimited newcomers, including those who are not guilty of any of the acts of wrongdoing, relied on to support the injunction application. The court cannot identify the individuals who are restrained by the injunction. It cannot begin to assess the particular circumstances of each person to be restrained, whether an injunction is necessary in that person's case, and whether the terms of the injunction are proportionate. See Bromley. It's difficult to see how the claimant would begin to demonstrate the required evidence of irreparable harm if it cannot identify the persons who it claimed would cause it. Put shortly, it's impossible to carry out the required parallel analysis of an intense focus upon the engaged rights. In London and Bromley, the Court of Appeal expressed concern that closing down unlawful encampments on land and moving on gypsies and travellers must be regarded as a last resort. Prospectively, making a contra mundum injunction prohibiting all encampments is arguably worse. Members of the gypsy and caravan communities are generally entitled to have a proportionality of the measures affecting their Article 8 rights considered by an independent tribunal. I do not consider the availability of permission to apply to challenge a final injunction order after it has been made, particularly when the likelihood of it being exercised is illusory for the reasons articulated by Mr. Willers. Paragraph 222 above is an adequate substitute for proper consideration of the proportionality of the order before it is granted. Whatever a court might exceptionally be prepared to grant on an emergency basis by way of an interim injunction, it could not countenance granting an injunction in such broad terms by way of a final contra mundum order. To illustrate this, I would return to the hypothetical example of the traveller family pitching their caravan overnight at the Dagenham Road car park. And then there's a reference to the paragraph I've taken your lordship's to already. If London Borough of Barking and Dagenham applied for an injunction against the traveller family to require them to vacate the site, the court would be able to carry out a meaningful parallel analysis of engaged rights. It could assess the necessity for and proportionality of an injunction, for example, by considering the circumstances of the traveller family, the evidence of availability of other sites where the caravan could be pitched, the impact of any injunction on the Article 8 rights of the traveller family, any evidence that the family had previously caused damage or engaged in antisocial or other criminal behaviour, of any evidence of adverse impact that would be caused by the family staying overnight in the car park, and any Article 8 rights of nearby residents. Perhaps more importantly, perhaps most importantly, in the adversarial process, the traveller family would have the opportunity to make submissions to the court as to whether an order should be made, and if so, on what terms. The result of that analysis could well lead to the refusal of an injunction, or the traveller family being given a period of time before they were required to move on. In reality, and consistent with the guidance issued to local authorities, a short-lived encampment that was not likely to cause damage or nuisance would be unlikely to lead to an application for an injunction in the first place. However, if a contra mundum injunction had already been granted, the traveller family would discover on arrival at the Dagenham Road car park that the court had already prejudged their circumstances and granted an injunction with a power of arrest attached, prohibiting them from pitching up even for a single night. It cannot be argued by the local authorities that contramundum order is the only way in which they can tackle the problem of unauthorised encampments that cause the sort of damage and harm upon which Wolverhampton relied. As noted above, the local authorities already possess what had been described as extensive power to tackle unauthorised encampments and the harm associated with them. In some of the evidence filed by local authorities in the cohort claims, complaints are made that some of these remedies are not as effective and/or are more expensive than civil injunction. That evidence falls a very long way short of demonstrating that contramundum civil injunctions are the only way of preventing the harm caused by unauthorised encampments, Bromley at paragraph 109. For example, for the reasons already mentioned, civil injunctions may have a role to play in tackling unauthorised encampments, but as targeted measures were justified by the evidence against actual wrongdoers or those who present a real and imminent threat of wrongdoing, in proceedings in which those to be made subject to the court's jurisdiction have an opportunity to be heard. And then he goes on to say, travel injunctions in the cohort claims do not fall into the exceptional category that permits the court to grant a contramundum injunction. Now, we do say that that analysis is correct and that it is a mistake, as Mr. Justice Nicklin himself says, to move from an insertion that there will be circumstances where the particular local authority has found it very difficult to deal with a particular encampment, to a situation in which a wide contramundum injunction is granted, which necessarily has the effect of meaning that the Article 8 rights of the gypsies concerned, travellers concerned, have not been examined. Now, a number of remaining tasks. The first is the basis of the Venables jurisdiction. I'm not sure I'm going to answer Lord Reed's question of what this court will do if the Human Rights Act is repealed, but the basis of the present jurisdiction is fairly clear. If the law court will go to Venables, which is at page 2433.
If you accept that there is actual jurisdiction under Section 37, you're not having to read a statute up or a statute down. You're just having to make a judgment as to whether, in the extreme circumstances, such as Venables, it's appropriate for the court to make such an order. It's a matter of principle and practice rather than the Human Rights Act requiring one to read legislation in a different way.
It's certainly not a question. It's not a Section 3 case. It's not a question of reading legislation in a different way. No. It's a question of finding a basis for saying that the court doesn't act in persona, in the category of case which is in front of it.
Yes, but I mean, if the Human Rights Act has, if it were to be repealed, has required in the past the court to act in a way which is not contrary to convention rights, and the court considered that the circumstances such as Venables were circumstances where, notwithstanding the absence of the HRA, it was appropriate for the court to, in those extreme circumstances, exceptionally to grant a contramundum order. What is there to prevent the court from doing so?
I'm certainly not going to be the one who says that the common law couldn't fashion a remedy where the individuals in Venables faced a risk to life because of the activities of the media. It may be that the court would fashion a remedy. Yes. In those circumstances. That's not this case.
No.
I
was just addressing Lord Reed's example, yes. that if the case is extreme, the common law, or equity rather, could fashion a remedy.
Yes. Well, I'm not going to submit the contrary. Where we've got to at the moment is that the basis of the Venables jurisdiction is Section 6.
It may be that there is a sufficient basis under Section 37 for the exercise of that jurisdiction or a parallel jurisdiction. For present purposes, I think we need assistance, or I need assistance, as to what might be the limits on that, and why it is or is not appropriate to extend it to circumstances.
Can we go to Venables, and I'll try and answer your Lordship's question. Let me go to Venables, and I just want the holding in the head note.
And if you can hold that in your head,
Yeah.
it also asks another question. I'm just slightly concerned that we may be. Well, I'm not sure I'm quite following this aspect of your argument. You addressed us earlier on the footing that jurisdiction in personam is established by service. See Cameron.
Yeah.
Right. And when you talk about the jurisdiction conferred by, well, perhaps conferred is the wrong word, because it may just reflect what the law was before the statute.
Yeah.
When you talk about the jurisdiction conferred by Section 37, are you using the word jurisdiction in the same sense? I mean, if you are, then what does Cameron have to do with it?
Well, let me go to the dicta about the different meanings of the word jurisdiction. I'm now, I think, trying to field two questions simultaneously.
I just thought that this was an issue that might be capable of being resolved before we had to go to Venables itself to answer Lord Jones's question. I mean, Section 37 tells us that the court has the power to grant an injunction whenever it's just and equitable to do so.
Yes. Now, plainly, Section 37 was in play in Cameron, and well, yes. That's wrong.
I mean, is there an additional requirement to constitute personal jurisdiction against the defendant?
The forerunner of Section 37 was in play in times in Spycatcher, and it's Spycatcher is only an example of a line of cases about the nature of, I'm not going to say power to grant injunction, about the nature, the description of the circumstances in which the court will grant an injunction. And we know from the Times newspapers that the normal rule, at least, and I'm inserting the word normal deliberately, is that you, the court, will only make an injunction that binds the party that is before the court in a personal jurisdiction. Now, sure, Venables establishes that there is power to make an injunction contra mundum, but the reason why it's necessary to make the injunction in the case of Venables and not in Times newspaper is the personal rights of the individuals who would otherwise be exposed to a risk of death or serious harm. So whether you analyse it through the route of the Human Rights Act or some notional, I mean it's disparaging, but some alternative common law replacement for the thought, the basis of the jurisdiction remains the need to prevent the sort of extreme harm that Venables was concerned with. And the whole thrust of Mr. Justice Nickling's reasoning in the passages that I've just been reading to you is that local authorities don't come close to that in relation to the wide injunctions that are actually being granted, because they're catching people against whom you can't possibly say there's any risk of the sort of harm that was present in the Venables case. the passage I've been having in mind, it might help me, even if it doesn't help you, to have the passage in mind. If a court will go to Foy le Roux, that's the right way of pronouncing it, and the dicta at EF 23025.
Sorry.
3025.
3025.
Right.
Sorry.
Yes. But where are we?
At 3025, there's a heading, the first issue. Both the Deputy Judge and Sir Andrew Moyet referred to the issue as one of jurisdiction. But jurisdiction is a word of some ambiguity. The ambiguity was referred to by Lord Justice Pickford in Guaranteed Trust against Hannay. The first, in my opinion, the only really correct sense of the expression that the court has no jurisdiction is that it has no power to deal with and decide the dispute as to the subject matter before it, no matter in what form or by whom it is raised. But there is another sentence in which it is often used, although the court has power to decide the question, it will, that, although the court has power to decide the question, it will not, according to its settled practice, do so, except in a certain way and under certain circumstances. Mm-hmm. And then it goes. The references to jurisdiction made by both Sir Andrew Moyet and the Deputy Judge read as though they had in mind jurisdiction in the strict sense. If they did, then I think they were wrong. It seems to me clear that Mr. Justice Park had jurisdiction in the strict sense against the injunction, to grant an injunction against Mr. le Roux and Fintrade. Both were in the territorial jurisdiction of the court at the time the freezing order was made. Both were shortly after the freezing order when served with the originating summons. There is no challenge to the propriety or efficacy of the service on them. The power of the judge sitting in the High Court to grant an injunction against a party to proceedings properly served is confirmed by, but does not derive from, Section 37 of the Supreme Court Act and its statutory predecessors, and then it deals with the history of the provisions that lead to Section 37. And then over the page, the issue is, in my opinion, not whether Mr. Justice Park had jurisdiction in the strict sense to make the freezing order, but whether it was proper in the circumstances, as they stood at the time he made the order, for him to make it. This question does not in the least involve a review of the area of discretion available to any judge who is asked to grant injunctive relief. It involves an examination of the restrictions and limitations which have been placed by a combination of judicial precedent and rules of court on the circumstances in which the injunctive relief in question can properly be granted. So it's on the basis of that passage that I accept that there is jurisdiction in the strict sense.
Yes.
Under Section 37.
Well, that was my understanding, that there was strict sense jurisdiction under the Act, but you invoke principle and established practice,
yes,
including the strong rules against breach of natural justice,
yes,
to limit the circumstances in which that power can be used.
Yes. And except for the contramundum jurisdiction, of which there were a very limited number of examples, the injunction jurisdiction has always rested on the basis that it flowed from the personal, the jurisdiction over the personal jurisdiction over the individual who was injuncted. Mm-hmm. And
you mean that in relation to final injunctions?
Yes. 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 I mean, none of this is subject to the. I'm not now dealing with the jurisdiction described by Lord Sumption in Cameron about interim injunctions granted on an emergency and conditional basis. But in relation to final injunctions, the statement by Lord Scott in the passage we're looking at is whether it was proper in the circumstances they stood at the time of the order to make it. Doesn't involve a review of discretion. involves an examination of restrictions and limitations which are in place by a combination of judicial precedent, etc.
Yes. And it's quite useful to see that Lord Scott goes on towards the bottom of the page to explain that the power doesn't actually derive from Section 37, but from the pre-1873 reform powers of the Chancery Courts.
Yes.
Yeah.
So it's actually a mistake to say that the power derives from Section 37. It's given effect to by Section 37, which is in itself the modern place where you find the power.
Yeah.
Or if we go back to the head note, consistently with the passage we're looking at, the holding is indeed expressed in terms of that the court had jurisdiction in the strict sense. We're looking at EF 3016, letter F. Jurisdiction in the strict sense to grant an injunction where it had in personam jurisdiction over the person against whom it was sought. So even in this case, Foy LaRue were envisaging that it's pretty well an absolute requirement that you have personal jurisdiction over the individual concerned.
Yes. And in the second part of paragraph 25, Lord Scott treats the judicial precedent and rules of court as being guides to the circumstances in which injunctive relief can properly be granted, rather than as jurisdictional.
Yeah. But Mr. Willers points out that the head note that I've taken note of is reflected in paragraph 30 of Lord Scott's judgment itself. Page EF 3028. 3028. Yep. So the proviso there is that the court has personal jurisdiction.
Yes.
I don't think I'm terribly wedded to whether the absence of personal jurisdiction takes one out of the first sense of jurisdiction to make the order in the earlier dicta we've been looking at, or simply forms an extreme example of the sort of restriction that one finds on the exercise of the power. You end up in the same practical situation, which is what Mr. Justice Nicklin, which is where Mr. Justice Nicklin arrived at, that the case was far removed from the sort of case where a contramandum order had been made. And once you got there, then there was no basis for departing from the general rule that the injunction had to be granted against people who were within the personal jurisdiction of the court. So I think I've got 3 more tasks, which I'll try and do on my timetable. First is Venables, but I think that can be dealt with fairly shortly. Your Lordships will find Venables. At 2433. And the basic shape would be discerned from the head note. which is at 2433. Held 1 that the Convention did not give rise in private law proceedings to freestanding causes of action based on Convention rights, but the Court, as a public authority, was obliged in such cases to act compatibly with Convention rights in adjudicating on common law causes of action, and that by virtue of Section 12.4 of the Human Rights Act 1998, the Court had to give direct effect to the right to freedom of expression under Article 10. Two, that by virtue of Article 10.1 of the Convention, the freedom of the media to publish could not be restricted, and the need for such restrictions fell within the exceptions in Article 10.2, which were to be construed narrowly, that the onus laid on those seeking such restrictions to show that they were in accordance with the law necessary in a democratic society to satisfy one of the strong and pressing social needs identified in 10.2 and proportionate to the legitimate aim pursued, that taking into account the Convention rights secured by Articles 2 and 3, the law of confidence could exceptionally extend to cover information as to the identity or whereabouts of individuals where its exposure will put them at risk of serious injury or death, and in such circumstances the need for restrictions on the freedom of the media would fall within the exceptions of 10.2, and that accordingly the Court had jurisdiction to grant the injunctions sought. And then granting injunctions in each case that on the evidence, the disclosure of new identities to be afforded to the claimants on their release would have disastrous consequences for them, including the real and strong possibility of serious physical harm and death, and that in order to afford them the protection they needed and were entitled to receive, the Court had to grant injunctions against the world, permanently protecting information as to their identities, present and future whereabouts, present appearance and similar information, and prohibiting disclosure of information which might lead to identification of the units in which they've been held, but disclosure of other information relating to their period in secure units when they're under 18 would not be prohibited by injunction, even though much of it was confidential. And the passage in which that's stated is at page 470 of the report. That's C to G.
Sorry, page?
470 of the report, that's EF 2473. That is, in fact, paragraph 104, simply stating the conclusion that there were compelling reasons to grant injunctions to protect, in broadest terms, the following information. The relevant information is set out. And the reasoning why the Human Rights Act is engaged is at paragraphs 25 to 26 of the judgment. EF 2449. And the last sentence of paragraph 25, considering Douglas and Hello. So as I understand the structure of the judgment, Dame Butler's loss considers Douglas and Delow, holds that she has to treat the rights under Section 10 and the exceptions of Section 10 as directly applicable, as between one private party to litigation and another, in the jargon its horizontal effect, and then comes to the conclusion about what's included within the exceptions. So it is, as it stands, entirely a Human Rights Act jurisdiction.
Using jurisdiction in the strict sense,
Yes.
you would say.
Yeah. Yes, using jurisdiction in its first and proper sense, but recognising that were the Human Rights Act repealed, the court might have another look about as to whether there was some other basis on which it could all be explained. I mean, I'm not.
Here, 2450, paragraph 29, there's the quote from that very famous passage in Spry. There's the citation of that famous passage in Spry on equitable remedies, which we see cropping up all over the place.
I'm sorry to go back over something we looked at a minute ago, but reading Lord Scott in Fourier, it seems to me that he does treat the constitution of personal jurisdiction by service as essential to jurisdiction in the strict sense.
Yes, I mean. I think I stand by my formulation. Either it is essential to jurisdiction in a strict sense, or it's a very powerful restriction which is only being overridden in the sort of circumstances envisaged by Venables against a background of fundamental rights as important as life, frankly.
Well, it may be quite important, which it is, and it seems to me that the implication of particularly paragraphs 26, 29 and 30 is that service is essential to the courts having jurisdiction in the strict sense.
Certainly, yes.
At the moment. I mean, for example, if one goes to 3027, the top of the page is he's dealing with Lord Diplock's judgment speech in Mrs. Skinner, and if you look at the last 5 lines, the effect of Lord Diplock's reasoning was that service of the writ on the Panamanian Company had to be set aside, at which point there was unarguably an absence of any jurisdiction in a strict sense to grant any injunction against the company. Paragraph 29 is quoting approvingly Lord Brown Wilkinson's speech in the Channel Tunnel case, letter F, although respondents have been validly served, i.e. there is jurisdiction in the court. And paragraph 30, as you took us to before, these authorities show that provided the court has in personam jurisdiction over the person against whom an injunction is sought, the court has jurisdiction in a strict sense to grant it. So it's not, service isn't simply a matter of practice.
Well, I can, yes. In a sense, the bottom line of my submissions is that no one can point to a case in which the injunction jurisdiction has been exercised against someone who is not a party to the proceedings, and therefore on that basis within the personal jurisdiction of the court, except in the limited number of contramundum cases, which by definition bind people who aren't within the personal jurisdiction of the court. And so one has to go on to consider Mr. Justice Nickling's reasoning as to why a contramundum injunction isn't available in the present case, which in my respectful submission is convincing. Now, can I just do my best to discharge a couple more of my tasks before past? Can I pick up a Court of Appeal judgment in our case, which starts at year 47. I can just highlight a number of matters. If we look at paragraph 71,
'71 of the Court of Appeal.
71 of the Court of Appeal, EF 446. So the starting place, if I invite the court to read paragraph 71, is to envisage a potentially wide jurisdiction on the basis of which contramundum injunctions could be granted. And then paragraph 72 then proceeds on the basis of the width of section 37. The formulation in my submission in paragraph 72 ignores the spy catcher and foileroo limitations or absence of formal jurisdiction, however one puts it, that we have just been investigating. 75 disagrees with what Mr. Justice Nicklin says at 174. And states that no such fundamental principle is stated in any of the cases. Such a principle will be inconsistent with many authorities, not least Venables, Gamble and Innes. In my respectful submission, that's simply wrong. We've looked at Venables for the basis for the jurisdiction in that case. Gamble is treated by Lord Sumption in Cameron correctly as an example of an interim injunction where the machinery of effective service by breach of an interim injunction is available. Very conceptually very difficult proposition. And he refers, the court refers to the highest that Canada Goose put the point was to refer to the usual principle derived from Spycatcher to the effect that a final injunction operated only between the parties to the proceedings. Principle was said to be applicable in Canada Goose. And the Master of the Rolls goes on to say that Canada Goose described the principle as consistent with the fundamental principle. A person cannot be made with jurisdiction without having such notice of proceedings, said to be without disapproving the mechanism explained by Sir Anthony Clark in Gamble, by which a newcomer might become a party to the proceedings by knowingly breaching a person's unknown to an injunction. So the analysis is dependent upon the mechanism in Gamble, and for reasons which I developed and can return to in reply, we say that mechanism is fundamentally unsatisfactory in the context of what I've been calling a final injunction, but something arrived at the end of the proceedings. So whether it works or not in relation to interim injunctions, the idea that you're injuncted, even on the basis of an order made with liberty to apply, in proceedings to which you were never a party, is contrary to all the case law which we've just been looking. And then finally, can I just draw the court's attention to the passage EF 452, conclusion on the main issue is in paragraph 101. There's a heading, the guidance given in Bromley and Canada Goose, and in this case by Mr. Justice Nicklin. 102 states, we did not hear detailed argument either about the guidance given in relation to interim injunctions against persons unknown, or in relation to how local authorities should approach persons unknown injunctions in unauthorised encampment cases. Would therefore be inappropriate for me to revisit in detail what was said there, but I will make the following comments. And the second of those is important to those I represent. Secondly, I doubt whether Lord Justice Coulson was right to comment that there was an inescapable tension between Article 8 rights of the Gypsy and Traveller community and the common law of trespass. And two, the cases made plain that the Gypsy and Traveller community have an enshrined freedom not to stay in one place, but to move from one place to another. Now, Master of the Rolls' attack on that is that it's not right to say that either Gypsy or Traveller community or any other community has Article 8 rights. No doubt that is strictly true, in the sense it's not the community has Article 8 rights, but it is composed of a set of individuals who do have Article 8 rights. And the effect of the procedure that the Court of Appeal has endorsed in this case is to mean that the proportionality of any interference with those rights of the individuals is not dealt with until the application to set the injunction aside, which for all the reasons given by Mr. Justice Nixon is fundamentally unsatisfactory. And secondly, that paragraph ends with the observation that the landowner, by contrast, has specific convention rights under Article 1, Protocol 1, to the peaceful enjoyment of particular possessions. The only point at which a court can test whether an order interferes with a particular person's private and family life and the extent of that interference and whether the order is proportionate is when the person comes to court to resist the making of an order to challenge the validity of an order that has already been made. So the court is envisaging the sequence of events that I've described. And the landowner, in this context, to the local authorities, they do not have Article 1, Protocol 1 rights. They are an emanation of the state, and they do not have human rights. So there's a simple error about the balance between the Article 8 rights and the rights of the local authorities. So we are, our next protocol is the lengthy and very carefully considered judgment in Bromley, which a court will find.
I suppose it might be said that only takes you so far. Obviously, it's true that no public authority has human rights, but if you were carrying out an Article 8 assessment and the justification put forward was protection of the rights and freedoms of others and so forth, then you wouldn't be looking at the local authorities' rights, but
you'd be looking at the neighbours or whatever. Yeah. I completely accept that.
I take the point, but it only takes one so far.
Yes, yes. Well, I mean, a more attractive way of putting it is that we invite the court, I'm not going to be able to do it now, but to read the whole structure of the judgment in Bromley, which is very carefully considered, sets out with care the background of the guidance, the nature of the human rights jurisdiction, the human rights court consideration of the rights of travellers. Yes, I know. Yeah, I know. So that's apparent on the face of Venables. And I think the best I can do is to invite the court at leisure to read the head note, and then if the court looks at the structure of the judgment, the court considers, or if Lord Justice Coulson starts to consider the relevant law at page 2180. There's a passage at 2181, paragraph 29 through to 35, under the heading Queer Timid Injunctions Against Persons Unknown. And it draws attention both to section 6 and spycatcher, first instance. There's a consideration of mayor under the heading Queer Timid Injunctions to Prevent Likely Trespass, paragraph 36. And I just draw attention to the way in which Baroness Hale formulated her endorsement of the further possible incremental development of the law in relation to trespassers, which is at just above letter C, 1058 of the report, 2183 of the bundle. And what she says, just above letter C, provided that an order can be specifically tailored against known individuals who have already intruded upon the claimant's land, are threatening to do so again, and have been given a proper opportunity to contest the order, I see no reason why. I see no reason, in principle, why it should not be so developed. I think that's actually in the context of possession orders, which is plainly recognising the importance of identifying the parties. And then going on to 2185, there's a long and important passage dealing with South Bucks and Porter. The heading immediately above paragraph 40 is Article 8 in the Gypsy and Traveller community. There's a reference to the decided cases of the Strasbourg Court. Chapman, Connors, Yordanova, and Buckland. Then, as I indicated, he deals with the relevant statutes and guidance 2189 through to 2191. And the detail of the guidance that he cites is in paragraph 54 and is important for the proportionality of an order that prevents anyone moving, even for a limited period, onto a site within a local authority's area.
That's different guidance from the 2015 guidance that we had a reference to earlier. I think these are earlier pieces of guidance up to 2006.
Yes. Have we got? Yeah, I don't think we've got the text of the 2015 guidance, but I will make that good overnight.
Thank you.
And then he goes on under the heading Analysis of the Appeal at 2191 to consider the appeal, decides that the judge had refused the injunction. And he gives wider guidance at 2198, paragraphs 99 of the judgment through to 109.
Sorry, paras?
99 to 109. Page 2198. And the conclusion at 109, court can read for itself, is obviously very important. Now, I think I've reached the limit of my time. I'm conscious of not having addressed the actual judgment in Carroll.
Yes.
We'll see where we get to on that, and I may come back to it.
Yes.
Those are my submissions for now.
Thank you very much, Mr. Drabble. Ms. Harrison.
Yes, I'm afraid we're just going to do it.
Of course.
Anyway.
Thank you very much.
Oh, I need to. Okay, sorry. Thanks very much. My Lords, I appear on behalf of the well-known campaigning organisation Friends of the Earth, who has been a dedicated organisation committed to raising the issue of environmental challenges that the country and the world face since 1971. We recognise, of course, that the Court is concerned here with high principle, but one of our reasons for intervening was to provide the Court with what we respectfully submit is evidence of actual reality, of practical consequences of persons unknown injunctions as they have affected the particular constituency that I represent, the campaigning organisation and its community groups and its some 300,000 members. I, of course, can't take you to that evidence. We've summarised it in paragraph 4 of our written case. I would particularly emphasise paragraphs 14 and 15, this is in the witness statement of Mr Timms, what's described as chilling effect on protest. So even though it's always said that these injunctions are aimed at curtailing unlawful protest, it is quite clear from experience, recognised by courts and particularly the INEOS case, that there is a chilling effect on lawful process as well as curtailing conduct said to be unlawful. And at paragraphs 18 to 31, which is at page 1791 to 1796, Mr Timms sets out the practical challenges that Friends of the Earth and others have faced in seeking to contest persons unknown injunctions. I ask the Court to look at that evidence carefully. It informs our submissions that we've made in writing, and I make orally to the Court now. We hope it will have some influence on the extent to which this Court will make its judgment on the issues of principle. Our primary submission on the questions of law is that it is wrong in principle and not open to the Court using its power under Section 37 of the 1981 Act to grant an injunction against persons unknown who are not parties to the claim when the order is made. We've described them as newcomers and who are both anonymous and unidentifiable. Both are examples of Category 2 cases identified by Lord Sumption in Cameron at paragraph 13 and are impermissible. A newcomer is not a third category. The judgment of the Court of Appeal in INEOS upstream at paragraph 29 to 30, page 2363 in the electronic references is wrongly decided. A person who is unidentifiable because they do not yet exist and indeed may never exist is a priori a Category 2 case, and in any event, the underlying reasoning of Lord Sumption in Cameron at paragraphs 17, 18, 21 and 25 as to why Category 2 cases are impermissible apply with at least equal, if not greater force, to newcomers. We do say in the alternative that if such novel and extraordinary orders are to be approved against newcomers, they must be limited to an interim measure as an exercise of an exceptional temporary jurisdiction or be necessary to prevent an identified substantial risk of serious irreparable harm to fundamental human rights within the rubric of the established Venables jurisdiction. And we address our arguments in the alternative in our written case at paragraphs 25 to 41, that's pages 353 to 360, and paragraph 43 to 44, page 360 to 361. And I won't focus on our alternative submission in the short time that I have, but it will instead focus on our primary submission and identify three core reasons why we say the Court should not adopt, as a matter of principle, persons unknown orders of the kind that we're discussing. And those three core reasons are, first, that such orders are contrary to basic and fundamental principles of procedural fairness, natural justice, and indeed we respectfully submit the rule of law. They require but do not have clear and express statutory authorisation, criteria and procedure rules to regulate their exceptional use, and without that, practice demonstrates both in the gypsy and traveller context but also in the protest context that they do become default mechanism and de facto means by which social issues of the kind that Mr. Drabble is concerned with and management and control of protest become the norm. Our third reason is that they have arbitrary and disproportionate adverse impacts on fundamental rights. Again, you've heard that in the context of Article 8 and the Gypsy and Traveller context, but obviously on behalf of my intervener, Articles 10 and 11 and the common law protections for free speech and assembly. We say in particular in our written case that there are two aspects of their operation that contravene and have significant implications for Article 10 and 11 rights, and that is their chilling effect, and it is also because they seek to regulate and control protest in areas that are already covered by extensive provisions of the criminal law, and go further and seek to also regulate conduct that is not contrary to the criminal law, is not even in its own right tortious. And we say in that respect, these are matters that should be dealt with by legislative enactment rather than judicial decisions. That's a point that my learned friend Mr. Bunting is going to develop, and so in terms of the division of time, I'm going to simply make that submission in the outset. It's dealt with in detail in our written case, and due to those time limits, I'm going to focus on our two principled reasons for objection. So first of all, addressing procedural fairness, natural justice and the rule of law, we respectfully submit that an order which binds a person who is not party to the proceedings when made subverts fundamental principles of our system of civil litigation based on an adversarial process where both sides to a dispute enjoy equality of arms, procedural fairness and natural justice. This goes to the heart of the court's jurisdiction over citizens and the essence of what constitutes a fair hearing, the right to be heard before judgment and orders are made that curtail freedoms and regulate the actions and even intentions of citizens, and where enforcement may involve punitive measures of arrest, unlimited fines, or even imprisonment for contempt and risk of prohibitive cost orders. We respectfully submit that the court should not countenance and sanction a legal process where the citizens' opportunity to contest orders against them arises only at the point at which they are in breach of an order, and as the Master of the Rolls approved at paragraph 82 in the case below, that's page 448, even though they were held to be in contempt. This is the Gamel principle that is at the heart of this case, and it is respectfully submitted that Gamel on that point was wrongly decided. We submit that it is proffered as the answer to the fundamental problem of service that was identified by Lord Sumption in Cameron, and it cannot be that a person only becomes party to the proceedings at the same time that they breach the order and therefore face consequences of contempt. In paragraph 37 of the judgment below, the Master of Rolls explains at 437 that newcomers could make themselves parties to an action by knowingly doing one of the prohibited acts. Once Miss Gamel knowingly breached the injunction, she was both aware of the proceedings and made herself a party. The MR also identified at paragraph 85 the point in Cameron was that the proceedings had to be served so that before enforcement the defendant had knowledge of the order and could contest it. It is, however, on proper analysis and clear that it is only on enforcement that the person becomes a party and has no means to contest it before enforcement, because by this point they will already be in contempt, as the Master of the Rolls accepted at paragraph 82. This cannot meet, therefore, the complaint and the problem identified by this court in Cameron, and it provides no meaningful opportunity to be heard in practice, and that's for some very obvious principles and reasons. First of all, the order will of course be binding until set aside. Even if it is subsequently varied or set aside, it will be irrelevant to liability and contempt, even if it may have some impact on sentence, and that was recognised in the case of Gamel itself at paragraph 33 to 34, as well as in the case of Quadrilla, that's 76 to 77, page 2322. A critical and key aspect of the reasoning of the court below was that knowledge was necessary in order for the Gamel principle to work and to meet those critical objections. It was, as is clear from a number of paragraphs in the judgment below, paragraph 31, 75 and 82, that the Master of the Rolls' reasoning depended upon the person knowingly doing one of the prohibited acts. That was the prerequisite for the Gamel principle working, but in fact the authorities make clear that knowledge of the terms is not a prerequisite for contempt, and again may only be relevant to penalty. And we cite in our case the case of Katurian at page 2895, paragraph 57 to 62, which also quotes the Quadrilla case at paragraph 25. As has already been made clear by my learned friend Mr. Drabble, that of course on contempt there is no question of any discretion being exercised and no balancing exercise will be conducted. That's again the Gamel judgment at paragraph 32 to 35. You will now be aware of how that's relevant in the context of Article 8 and Gypsy and Travellers, but of course it has equal relevance to cases concerning Article 10 and 11, where the complexity of the proportionality exercise is clear. It will include consideration of facts such as the time, place, manner and duration of the protest, the nature of the extent of its impacts on others, even in cases of trespass, as we know from the case of Samidi, which is at paragraph 39, page 2870 of the electronic bundle. There may be questions of lawful or reasonable excuse based on the common law case of Jones. That case is at page 258 to 259 of the bundle, and of course proportionality, recently considered by this court in Ziegler, where it applies at paragraph 59, page 2956, the electronic references. So we respectfully submit that set aside or variation before enforcement is not a solution in principle to the problem identified in Cameron, and as my Lord Briggs identified, is an unreality in practice. It is a theoretical and illusory remedial measure for the radical unfairness in the making of the order in the first place. In a protest context, it would, for example, require the person who from desist in participating in the immediate protest and make an application to the court, defeating the very object of the purpose of the application. The Hampshire Waste case, which is at page 2353, paragraph 4, one of the first cases in which such an order was made in the protest context, would render the action irrelevant because that was a protest on a single day. Persons would also have to have the financial means to make an urgent application. There is no public funding for set-aside or variation applications in this context. Friends of the Earth have explained how they became at risk of a liability of a penalty of a costs liability of £85,000 when they sought to vary the injunction in the Quadrilla case and had to withdraw after
if I'm understanding it, a point made in the witness statement is that apparently you can't obtain a cost protection order.
You can't have a cost protection order, that's right.
Because these are private law proceedings.
Because it's private law proceedings, so it's not possible, but it does therefore mean that this particular form of proceedings, costs in those kinds of sums is not uncommon, and that clearly has a significant impact on the willingness and ability of any ordinary citizen to seek to set aside such orders.
Yes, and another problem that's raised in the witness statement, which I had more difficulty following, is that we're told that the parties who've obtained talking about an interim injunction, it's been sent, in inverted commas. I don't know. It doesn't seem it's been served, but the interim injunction has been sent to Friends of the Earth.
Yes.
But the party who obtained the injunction has refused to allow Friends of the Earth to see the claim form.
There have been complex difficulties, and that was on the basis that they had to first of all agree to be a defendant.
Yeah, I mean, you become a defendant normally by having the claim form served on you.
Yes, well, because they were not alleged to have been involved in any kind of unlawful conduct, then of course it wouldn't be appropriate to serve the claim form on them. And that is the difficulty, that in the cases where they've been contested, whether that's through Friends of the Earth or some identified individuals in both the INEOS and the UKOG case, those individuals were not alleged to be involved in any kind of criminal conduct or tortious conduct. They, however, had to become defendants to the proceedings, but then the orders were not made against them, so that in principle they were the only people that the orders were not made against, even though there still is a question of whether they remain persons unknown. So those are some of the absurdities that have arisen in practice, and they presented the problem for the Court of Appeal in INEOS that the two individuals were not in fact parties to the case anymore, but they had brought the case before them. So there are, at a very granular level, significant absurdities and consequences that do arise for those who seek to in the public interest, contest persons unknown injunctions.
Yeah, I mean, at that level, it may be that there are practical. If Mr. Drabble lost on the point of principle, there may be practical solutions to the practical problems.
Well, there may be, but what we do have to look at, and this was the point that I was going on to make, is that one of the factors that is relied on heavily below is that these cases do not result in contested applications and there are no trials. But that begs the question as to why. It's because, in fact, practical solutions do not exist, and it does mean that in reality the proceedings are effectively one-sided, and it is intrinsic to the nature of the process where you have a persons unknown injunction that they are categorised by being one-sided. And that does reflect the departure from normal processes of civil litigation, the prohibitive costs orders, the uncertainty that's involved. Friends of the Earth have explained how difficult it is to make a judgment about your likely success in the context of orders of this kind, and how the lack of any clear express rules and rules set out in advance make it extremely difficult to decide whether or not you would contest it, precisely because you're at risk of very substantial cost orders.
Yes, I don't think you don't address, do you, in your anywhere whether the Aarhus Convention might give you some, well, might encourage domestic courts to give you some protection in relation to costs.
That was something that we considered, and it wouldn't. That was also raised before in the case where we were refused a PCO before His Honour Judge Pelling. So he rejected all of the arguments that we advanced. And in any event, whilst that may assist Friends of the Earth, it wouldn't assist an individual necessarily who was seeking to contest such an application. But ultimately we say, given those profound and unjust consequences, there is a need for something more than the broad discretion in Section 37 of the 1981 Act. It isn't provided by the overriding objective, which was the position that the Vice-Chancellor took in the Bloomsbury case at paragraph 19, nor a resort to the principle from the case of Meyer, where it is, if you have a right, there ought to be a remedy. And it's important to recognise that Baroness Hale caveated that broad principle by the need to ensure that there is a proper procedural protection for those whom the remedy may be granted. And I'd also invite the court to consider the important qualification to that principle, which is heavily relied upon by the respondents and in the court below, in the judgment of Lord Neuberger at paragraph 59 at page 408. Judges are not legislators, and there comes a point where in order to deal with a particular problem, court rules and practice cannot be developed by the courts, but have to be changed by primary or secondary legislation. And we respectfully submit, for the reasons that we developed in our case, that we have reached that point. And in this regard, if I can just make reference to the fact that it is significant that in the Town and Country Planning Act in 1990, Section 187B, Parliament did make specific express provision for persons unknown injunctions, but we respectfully submit did so in circumstances where, whilst the person was anonymous, they were identifiable. So where Parliament has intervened in this respect, it has not encompassed newcomers, but has followed the approach later identified by this court in Cameron as correct, and limited it to Category 1 cases. And we would also finally draw attention to one other area in which the court, in which there has been specific provision for orders that bind persons who are not directly party to the proceedings, in the sense that there's representative proceedings. That's in CPR 19.6. But the courts there have been keen to ensure that the safeguard within CPR 19.64 is applied, and that is that it will not be enforced against those who are not party to the proceedings, so that there is a safeguard where representative proceedings are in place. And we address that by reference to two cases. That's the Estella Farmer case at paragraph 20, page 2633, and by way of example, the N-Power case at 40 to 44, page 3996. And in that respect, they addressed the conundrum that we have here by requiring the court to give leave before enforcement of such an order could be made for non-parties. And we respectfully submit that is indicative of the fundamental problem identified in our written case of breach of natural justice and fairness, which in itself would be a significant limiting factor on the exercise of any discretion.
You're being passed a note, but you have to deal with it very quickly.
Yes, it's obviously to make it clear that the 1990 Act was introduced after the Senior Courts Act. I think that follows. My Lords, those are my submissions, unless I can assist you further.
Thank you very much. No, I'll let you go on because it was worthwhile, but it means we haven't got to Mr. Bunting. What I would suggest is, if parties are able to do this, the court could sit at 10:15 tomorrow morning to make up the time that we've effectively, well, it's not been wasted, but we've run behind our timetable. So if that suits parties, then we'll sit tomorrow morning at 10:15. I don't see any dissent. Very well. So in that case, we'll adjourn now for the afternoon.